Welcome back to the second part of Intestacy in the law of succession. We will carry on, of course, looking at the historical angle in respect of the intestacy rules and how they have developed over time. Now, in the last segment, you heard me say that up to a point, i.e. before 1926, that the position was that there was a difference between how realty and personality were dealt with. Well, after 1925, there became a unified system. Well, a unified system was implemented, which meant that the system applied to all property of the intestate. So there was no difference anymore on how real property was dealt with or how personality was dealt with. Also, the position between the widow and the widower was equalized. So, of course, by now I suppose they started having some women making the laws. So what we get is that there's some equality in the way the property was being devolved to persons. Now, the Act then repealed previous laws, and what we saw was that the primacy was to the surviving spouse. So what you then got was 100% going to the widow or the widower. What we then also get is a statutory legacy in place of £1,000. And the whole idea is that the primacy becomes even more evident by the time we get to 1952 and the Intestates Estates Act of that year. The statutory legacy also became increased to £5,000. Now remember what the statutory legacy is. We're looking at where, for example, the spouse gets, first of all, from the estate, the statutory legacy, then all of the personalty, then of course, the half of the remainder, either absolutely if there's other next of kin, or half with a life interest if there are children. So what we get by 1952 is a statutory legacy increasing to about £5,000. The spouse was then also given the right to get the matrimonial home in satisfaction of the statutory legacy. What I want us to consider, and I want you to take on board and bear in mind as we look at the statutory legacy, because you will see that over time, Parliament has made changes, they have reviewed it, the Law Commission has made recommendations, simply because when you look at the statutory legacy, it appears as if one of the things that they want to be able to do is to allow the spouse to remain in the property. That's how it comes across anyway. And therefore, by increasing the statutory legacy, it means that the value of the house is also taken into consideration. All right. So by 1952, we see the statutory legacy increasing to an amount which might more or less cover the value of property around that time. Now, subsequent legislation has sought to make some improvements. Well, whether or not you can call them improvements depends on whether we're on the line of the divide you stand, because they sought to improve the position of illegitimate children to bring it in line with legitimate children. And illegitimate children, for those too young to remember, of course, are children who were born outside of marriage. And there was a different way of them acquiring under the succession laws simply because they were born outside of the marriage or born to somebody else who is not in the marriage. So 3 of us in this marriage, as the case may be. Well, be that as it may, what we see this subsequent legislation doing is increasing, for example, the statutory legacy as well. So it improved the position of illegitimate children. It increased the statutory legacy. And the act, of course, responsible, we see, are the various law reform succession acts. And in particular, the Law Reform Succession Act of 1995 introduced a somewhat unique feature, which was that the surviving spouse can only now take if the surviving spouse survives the intestate by 28 days. This, of course, meant that if the spouse died within 2 weeks, probably because of a broken heart, I imagine, it meant that it was as if that surviving spouse, who died later on, had predeceased the intestate. And so it will go back on the basis of how intestate succession would be as if that partner had predeceased him. What that Reform Act also did in 1995 was to abolish the controversial hodgepodge provision of the AEA, the Administration of Estates Act. Hodgepodge really talked about or really dealt with situations where certain beneficiaries prior to the death of the intestate had received certain goods from the intestate. What Hodgepodge said was that beneficiaries who had an interest or received an interest before the death had to account for the benefit they had received, and then it may actually be drawn back into the pool, as it were. So hodgepodge was then abolished. There was also a recommendation, but only a recommendation at that time, that the spouse take the whole estate. This, of course, was rejected by Parliament, but we see that you do get a development where it seems to be largely slanted towards the spouse. If we consider for a moment, what is the basis? Why are intestacy rules, which are predominantly out of Parliament because it is heavily statutory based, what is the theoretical basis behind it? Why have the rules developed the way they have? Well, the idea is that it is supposed to reflect the presumed intention of the deceased. Well, so it should seem. So that is why it has this whole emphasis on the spouse. So it gives the spouse a particular position over children or other relatives. But that may be so. But consider for a moment, as it goes down the line, and there is no spouse, no issue, no defined relative, if the theoretical idea is to give some sort of credence to what the deceased may have wished, why should it go to the crown bona vacantia? So that is something for you to consider if, for example, an examiner asks you if the law reforms go far enough. So, would the testator or would the intestate have wished also that if the person they are living with but not married to, would they have wished for them not to get? And you have to think for a minute that the way the law is currently set up, it talks about spouses, but it does not talk about cohabitees. And the fact of the matter is, if you look at somebody who lives with another person and that person dies, then the law does not provide, not under the intestacy rules anyway, it does not provide as a matter of right how that person is to be dealt with in respect of financial provision. Of course, there are laws in relation to family law matters whereby that person may be able to take, for example, under the Inheritance Family Provisions Act. But as it relates to intestate succession, those persons are not really provided for. Would that be what the person would want? Not necessarily. Now then, we use these phrases and terms of arts, but we are not lay persons. So let's consider when we talk about surviving spouse, who or what qualifies as a surviving spouse? Who is a spouse? Well, we go to section 46 for this now. Again, I will remind you that when you look at the Civil Partnership Act of 2004, it does include civil partners in this as well. So going back to who is defined as a spouse, it talks about somebody who is lawfully married to the intestate at the time of death. Now, that may seem straightforward enough, but what you may not be what may touch a nerve a little bit is that it is irrelevant if the parties are going through a divorce. So what if the parties are going through a divorce? Now, for those of you who are not family lawyers or you are not doing family law as an option, in respect of divorce, there are two parts to a divorce. The first is that let's assume the court agrees with you, you are going to have your divorce. You first get what is called a decree nisi, which basically allows the court to say to you, you're fine, we agree with you, you can walk away from this marriage. But there is a 6-week period from the nisi to the absolute, because there's this old thing in English law that somewhere in that 6-week period, the parties might decide that, oh my goodness, we've made an error, and get back together. And if that happens, well, you don't go through with the absolute, you're basically still married. So there's that period between the nisi and, of course, the absolute. Well, this is what occurred in the case of Reese Seaford, a 1968 case, where the wife got a nisi, but she did not get the absolute. Now, the husband died a few hours before the decree absolute. I don't know if that is a good or a bad thing, but the court said that the marriage still subsisted and the wife was entitled to be the personal representative, which of course presumably means that she then had the right of intestate succession. And even somewhat arguably worse case, of course, is the case of Ray Collins in 1990, where there was a decree nisi against a violent husband. Now, the wife died before the absolute. Now, if this woman was seeking a divorce based on the fact that her husband was violent, it is highly unlikely she would have wanted him to have inherited what she would have left. But unfortunately, no will. This is what happens. And the husband inherited the whole of her estate. Now, if we go back to marriage and consider persons in a marriage, because we are looking at who qualifies as a spouse. Again, if you are not a family lawyer, there are some terms that you need to basically get up to speed on. The first, of course, is avoidable marriage. Now, avoidable marriage is where you have a lawful marriage, so the parties have gone through a process of marriage, but unfortunately, it is avoidable. Now, go back to basic contract law for this, because remember that marriage is the original contract. Okay, so what is a voidable contract? It is a contract which subsists until it is avoided. So, avoidable marriage is one where it is voidable under the grounds set out under Section 12. So, if there's a lack of consent issue, if there's a non-consummation issue, if you have married the person because of a mistake, these may operate to void the marriage, but it is subsisting until you raise the point. In Ray Roberts, the intestate lacked capacity because of mental illness, but the court said because the marriage had not been avoided, the widow was still entitled. In a void marriage, on the other hand, you're looking at something which is a complete nullity, because again, go back to contract law, void means void ab initio, meaning it is void from the start. So a void marriage is where it is void under the grounds set out under Section 11 of the Matrimonial Causes Act of 1973. So, for example, one of the parties lack capacity, or there are breach of certain formalities. Then there was absolutely no status of husband and wife in any event, and so they are not entitled under intestacy. There is, of course, the possibility of getting some sort of financial provisions under the Inheritance Provision for Family and Dependents Act 1975, which you can, of course, review for yourself. Interestingly, what about polygamous marriages? We are, after all, living in multicultural Britain, as it were. What about polygamous marriages? Well, the fact is that when you look at family law, there are issues in relation to family law to do with polygamous marriages, but that doesn't necessarily affect interstate succession. Now, an interesting case came up recently, although there were some doubts before. This is a good case for you to look at. The case is called Official Solicitor to the Senior Courts and YEMOH, Y-E-M-O-H. It's a 2010 case, and it goes like this. X, who lived in Ghana, had died intestate, and he left real property and personal property in England. He was survived by a number of polygamous wives, a number of children, and some of these brought proceedings against the administrators of his English estate. The court said that X's polygamous marriages under the customary law of Ghana were recognized for the purposes of succession law, and so they could succeed to his estate in England and Wales. Therefore, his surviving polygamous spouses were entitled to be recognized as surviving spouse spouses rather, for the purposes of Section 46 of the 1925 Act. Public policy objections to the recognition of polygamous marriages in respect of family law, as I said, is irrelevant here. The surviving polygamous spouses together, they said, constituted the spouse for the purposes of Section 46, under which there was a single surviving spouse statutory legacy which they shared in equal shares. So the court was trying to do right, of course, by everybody. The court said that the life interest until the death of the last of them, when that half of the residue would fall in for the benefit of the children. The court then went on to say that there was no basis under Section 46 for benefits under ex's Ghanaian intestacy to be brought into account. So the court didn't want to tread on any toes. It was really concerned with the property in England and dealt with it that way. Now, what if the parties are separated? Well, the spouse has full succession rights, but if it is a judicial separation, the court says that it is as if the spouse predeceased the intestate and you cannot take any interest on intestacy. What about cohabitants? Well, I've touched on this earlier. There's no rights on intestacy, but again, I would ask you to consider the statutory financial provisions under the Inheritance Provisions for Family and Dependents Act 1975. Now, again, I must remind you the spouse must survive the intestate by 28 days. We will, of course, pause at this moment, and when we come back, we will look at what is meant in respect of the entitlement, and we will focus somewhat on the statutory legacy.